As a landlord, something that many people tend to struggle with is not really understanding the compliance and all the things that they're liable for. It's very easy to trip up and miss something and make a mistake on compliance, but the penalties are severe. My guest on this podcast is Julie Ford, somebody who's an absolute authority when it comes to compliance. In fact, just in the last year alone, she defended over £123,000 of penalties for non-registration of deposits. We also talk about the Renters' Rights Bill, the hot topic right now, and more importantly, the things that you need to be doing or what time frames in order to get ready and protect yourself. So let's jump straight to the podcast. Julie, just last year alone, you've defended £123,000 of penalty claims for not registering deposits. I didn't realise the problem was that big.
The problem really is that big. More and more landlords just don't realise they need to protect the deposits, even though the law actually came in 2007.
But is that the biggest problem facing us right now? What do you think the biggest challenge facing landlords at the moment is?
I think that's definitely one of the bigger problems, but obviously with the Renters' Rights Bill on the horizon, we certainly have a bigger problem to deal with in the future.
Yes. And what things do you think we need to be aware of? Because there's lots of talk and some of the circles that that we're in property circle and people we speak to, some people think, well, I'm just going to wait until it's clear what's going to happen. And we were talking about this off camera, that actually waiting is probably not the right thing to do.
No, absolutely. We know now that the bill is going to move through Parliament. It's done its report. It's on its report stage now. So it's not suddenly going to be pulled. Somebody's not going to make a decision and a U-turn. It's not going to happen. So we really do need to prepare, because otherwise, failing to prepare is preparing to fail. So we absolutely need to be looking at what changes we need to make now for the Renters' Rights Bill.
And what are would you say, the key changes that are should be at the forefront of landlords, letting agents' minds right now?
I think obviously the biggest one is the abolishment of Section 21s. Section 21 is commonly known as a no-fault notice, meaning landlords don't have to have reason to evict a tenant. They're not going to have that luxury anymore. They'll have to have a reason under one of the 36 grounds that are coming in as Section 8. Now, also, we won't have fixed-term tenancies anymore. So where we've had the security of 6 or 12 months let, we won't have that. Tenants will be able to give 2 months' notice at any point, including on the day of move-in. And finally, rent in advance, I think, is going to be quite crippling for the industry as a whole. At the moment, if you've got a tenant who doesn't quite pass referencing, but they're a good egg,
yes,
you'd take 6 or 12 months rent up front. You're not going to be able to do that anymore. It'll have to be the first month's rent, and that's all. And I think that's going to really discriminate against a lot of tenants in the industry, which actually the government was actually trying to get rid of discrimination with this bill. And I think it's going to do the opposite.
Yeah, and I think that's a thing. I 100% agree with you there. I think the government miss that, although they're trying to protect tenants, and there's also a group of tenants that are going to make life very difficult for as well during this process. Landlords want to protect their interests, letting agents want to protect the interests of their clients as well. So there is going to be more challenges that some tenants will face. So let's unpack some of those things. So the first one around Section 21, it's our preferred tool for us when we need to ask a tenant to leave.
Yeah.
And the reason we tend to do that, and I've had this conversation with many people and says, why do you use Section 21? Why would a landlord want a property back? I say, look, if it's a good tenant, there's no antisocial behaviour, they're paying the rent on time, you don't want the property back. You want the tenant there. You're happy with that. The only time you want the property back is one of those problems. But the reality is, going through the Section 8 route is so painful that it's just easier just to go down this route. And that's why we've chosen to do that. What do you think is your thoughts on what we need to be thinking about and where around the loss of the Section 21?
So realistically, like you say, no landlord gets rid of a good tenant because that doesn't make business sense. Yes. It's going to be about evidence now. Most of the time it's rent arrears or antisocial behaviour are the main grounds for getting rid of a tenant. The rent arrears grounds are changing from the tenant being 2 months in arrears. It'll now be 3 months in arrears. The notice is changing from 2 weeks to 4 weeks. So technically landlords will be 4 months in arrears before they can even make an application to court. So it's going to be about understanding how to keep really good rent accounts so you can prove to a judge that there is actually those rent arrears in place. And the same with antisocial behaviour. Antisocial behaviour has always been a really hard ground to prove because sometimes antisocial behaviour is subjective.
Yes.
What you might feel is harassment, somebody else might feel is just banter.
Yeah.
So it's quite subjective in that way. But there are new rulings with regards to how it works in HMOs. So if an HMO tenant feels that somebody might be causing a nuisance to them, then you can use the ground. but it's going to be about getting witness statements, CCTV, report everything to the police, get a crime reference number, as much evidence as you can to get it past the judge.
Mm. And those, and I talked about this beforehand before we started filming, I think it's good practice right now for letting agents and landlords to be reviewing their current tenancies, and there may be some Section 21s they might want to serve now rather than leaving it till they. It's much more difficult to ask some tenants to go. In terms of the courts, which has been one of the biggest challenges, when you even when you serve the notice, it'll be months and months and months before you get to a point where you actually get a property back. Do you think there'll be something that will come in place to help support the revised Section 8, or do you think we will struggle along with what we've already got?
I think we will struggle along with what we've already got. Originally, when Labour came into power, Angela Rayner did talk about digitalising the court process, making a lot of the Section 8s go through very similarly to how Section 21 moved forward. That's now been shelved. And although we are seeing advertisements on the Ministry of Justice website for judges, I think the last advertisement went out, they were looking for 15 judges. It doesn't necessarily mean the courts are going to be available, because a lot of the county courts deal with lots of different types of cases, not just housing. And we tend to see housing is done maybe just on a Monday or a Wednesday. It has one day in court. So unless we're going to see a lot more courts opening maybe 24/7, to be able to get through the courts. I mean, we're already seeing at the moment the average is 24 weeks from service of notice to eviction. And a friend of mine today has actually said that in his local court in Nottingham, it's actually 7 months once you've got your possession order just to get a bailiff.
Wow, 7 months. I guess you've highlighted it's not just the fact of creating new courts, it's the judges, it's the bailiffs, it's the whole process.
Absolutely.
But at the same time, you'd think that if the evidence is there, it's a fairly straightforward process. It doesn't require necessarily a judge to look at it. If the evidence is all there, this can be processed very quickly, and it'd be an efficient process for everybody involved. But that doesn't look like that's going to be happening either.
No, absolutely. And the other issue that you've got with Section 8 is because most of the grounds you are accusing the tenant of doing something, not paying their rent or being antisocial behaviour. So under English law, they have a right to defend themselves, so they have to have a hearing.
Yes.
Whereas with Section 21, there's nothing to defend because you're not accusing the tenant of doing anything. So 9 times out of 10, there's not a hearing. And it's the hearings really that take up the time.
Yes. So the other thing you also mentioned then was the no 6-month tenancies anymore. That's all disappearing. Effectively, we're going straight into a periodic tenancy, where as soon as a tenant moves in, they can tell you, I plan to live here the next few years, and the day they're moving, they can literally say we're moving out in 2 months' time. They can give a 2 months' notice immediately. What do you think? What impact do you think that will have on the rental system?
I think realistically, it's going to be unusual. I'm not going to say it's not going to happen, but moving is one of the most traumatic things a human person can go through. So no tenant is going to want to move every 2 months just because the law says they can.
Yes.
Plus, it's a financial outlay moving. A lot of tenants can't afford another moving truck, another deposit. So it's going to be unusual. But I think landlords are going to be more protective about who they take as tenants. Are they going to shy away from single professionals because they're more transient? Are they going to want to look at the family, which is more secure, getting the kids in school? They'll stay past GCSEs, etc. Will it change the landscape of who landlords see as their target audience now?
And the other thing you also mentioned was arrears, in terms of how we deal with the arrears. In fact, with arrears, I want to come back to that in a moment, but something that slung my mind was the deposit registration that we started with. And the reason that's on my mind, because just last week somebody called me about a week and a half ago in a situation where they had a tenant that had been there a number of years, but actually they hadn't registered the deposit. And now they're asking a tenant to leave and stuff, and they realise actually there's a bit of a problem there. And as you've highlighted, that's not unusual.
No, it isn't. And a lot of it is a case of the landlord wasn't trying to be fraudulent or a rogue landlord or malicious in any way. It was just they didn't know the law. They haven't done their research. So in your client's case, obviously without seeing the situation, let's assume they had one tenancy at the beginning 6 or 7 years ago, no renewals. All that landlord needs to do is return the deposit in full, and they'd be able to issue a valid Section 21.
You've heard the phrase, your network is your net worth, and you'll also hear it in this particular podcast as well. That's because people in property recognize the importance of being connected with other people. Property is a people business, and that's the reason I've been running a networking event for over a decade now. Each and every month we bring like-minded people together, an opportunity for you to come along and meet some of those people and also learn from other people on the stage, learn from myself as well. So make sure you book onto the next meeting. We're on the third Tuesday of every month in Birmingham. Now let's get back to the podcast. And if the tenant realizes that and doesn't want the deposit back, they can make life a little bit difficult there.
It can, but there has been case law where landlords can return the deposit even if it's not accepted by the tenant. It would still be classed as returned, but you've got to do it in a certain way.
So there's some light at the end of the tunnel. If someone by accident hasn't raised the deposit, they didn't realize that was the problem that they're potentially going to face. So what's your background? How did you come about doing this and helping landlords and letting agents with compliance?
Right, that's a really great question. So I started out as a new build sales girl.
Okay.
And I very quickly realised I couldn't sell anything to anybody. This was not my thing. But as soon as somebody came back to the showroom and said, oh, a tile's fallen off the wall or the mastic's not right, oh, I was a fixer. I was a problem solver. So from that point onwards, I moved into property management because then I am solving everybody's problems on a daily basis.
Yeah, that's what lettings is, problem solving every day.
Exactly. So I sort of found my home there really in property management. And then just the legislation side just attracted me and I just got sucked into it.
Okay.
And then I worked my way up to head of property management for a large property and asset management company in the city. And then from that point onwards, I opened my own lettings and property management company, building it up to 500 single lets, fully managed. Sold that business and then moved over to the dark side.
Right.
And I started as a housing and homeless law specialist for the Citizens Advice. Did that for 6 years. And then I was a trainer for shelter. I've worked for homelessness charities as well in their housing departments. And now I'm a consultant in the industry. I'm also a trained mediator, mediating over 500 mediations for the property redress scheme.
Right.
And a trainer in the industry as well.
Excellent. And so for NRLA, you do some of the training for
absolutely. So I'm a freelance trainer for the NRLA, delivering a lot of their renters' rights bill training at the moment because it's pretty much the hot topic for everybody.
Yeah. And with renters' rights, what's your thoughts in terms of timing? What do you think is likely to happen when we should be starting to implement things as landlords and letting agents?
I think the sooner you can get things penciled in behind the scenes, knowing how you're going to have to change your systems, your business models, the better, because then you'll have it in the background ready to just press go and you're fully compliant. But we expect to get royal assent before summer recess, which is the 22nd of July. And then it's still expected to become law in October of this year. But there'll be certain elements that won't come into force because there'll be secondary legislation. So they'll be in 2026. Yeah. And that will be Decent Home Standard and AWAB's law, and quite possibly the database and the landlord ombudsman, because the software hasn't been written for those yet.
Yes. And you've been helping landlords and letting agents just trying to get on board with this, understand, get prepared for this as well as doing some of the training for NRLA and their members as well. Are there about 100,000 members now, I hear?
110,000, I think, yeah.
So it's growing. But considering how many landlords there are in the country, it's interesting that the membership is so low as well. It's surprising.
Yeah, absolutely. There's 2.82 million landlords in the UK, and the NRLA have 110,000. So although they have a lot of landlords as members, it's quite a small amount percentage-wise when you look at how many landlords there are out there. So we just need more landlords to join up.
And when we think about compliance and falling foul of compliance, is it mostly those are self-managing, or is it letting agents falling foul of that as well? Or
sadly, letting agents fall foul as well. Lettings is one of the only industries that is not regulated.
Yes.
So, anybody can wake up on Monday morning and go, I'm going to be a letting agent today. They open a client money protection account, get their ombudsman, and they're good to go.
Yes.
They don't have to have any qualifications or previous knowledge. And I think that's one of the biggest issues. Yes. There are people setting up in lettings thinking that it's a great money maker. Unfortunately, it's probably one of the worst money makers in the industry because you do an awful lot of work for not a lot of percentage.
Yes.
But also, whether they are big national firms or whether they're small high street independents, I see a lot of directors not seeing the value in investing in their staff. So they expect the staff to just pick it up as they go along.
Yes.
But unfortunately, they're being trained by people who weren't trained, who also picked it up as they went along. So 9 times out of 10, what's being fed isn't necessarily legally correct. And we see a lot of landlords fall foul of what the agents have done incorrectly.
And it's really about managing the managing agent and making sure that you have a good agent in place, and that you have some checks and measures in place to ensure that they're doing what they need to be doing, because ultimately they're representing you as the landlord. It's your responsibility as the landlord.
Yeah, ultimately, if the letting agent messes up, the landlord will be the one that gets the fine. So yeah, you do have to manage your managing agent, and I think it's important for landlords to understand that that agent is nothing more than an extension of them. The agent is acting for and on behalf of the landlord. So if the landlord doesn't have any idea about what the compliance is supposed to be, firstly, how do they then pick a good agent?
Yeah.
Because how do they ask the right questions? And secondly, how do they know that agent's doing a good job for them if they don't know what it is that's supposed to be happening?
Yeah.
So I think landlords will need an agent more than ever under the Renters' Rights Bill, but it's about picking an agent that knows their stuff.
Yes, and unfortunately, many landlords tend to shop on price. Who's the cheapest? And as you said, there's a lot of work that letting agents tend to do for a small fee. And if that fee shrunk even more, how are they actually able to really deliver a good service?
Well, that's the biggest problem for letting agents all round, really. You know, you've got letting agents out there that are delivering a phenomenal service for their landlords, but they're struggling to get landlords through the door because their fee is higher.
Yes.
Landlords obviously are looking at the fee because it comes off the rental income. It's their bottom line. It makes sense. But if you're employing an agent to do a job to protect you, to safeguard you, unfortunately, you have to pay for that.
And with tenants, a lot of our tenants tend to be young professionals, graduates, and our rents are kind of premium end of the market, generally speaking, in terms of the accommodation. But we'll have somebody, for example, a young doctor that's just arrived in the country, that haven't been here very long. They're not going to pass any credit checks. And we have to take a view. Do we think this person will be a good fit? And we'll ask for 3 or 6 months rent in advance to cover that sometimes. But all that's going to disappear. And what do you think we need to be doing as landlords and letting agents to maintain some level of protection?
I mean, ultimately, it's going to be about rent guarantee. So I would advise every landlord now to be paying for rent guarantee insurance, and also looking at guarantor companies. So normally you'd ask for, say, maybe mum and dad or uncle or someone to be the guarantor. If they're coming from overseas, then that's 9 times out of 10 not going to tick the box either, because the parents are going to be overseas. Yeah. So now we're going to be looking more at these guarantor companies. It's a safer option as well, because the guarantor companies are a business. They're entering a legal contract with you to pay the rent should the tenant not do that. Yeah. Whereas the bank of mum and dad sometimes like to argue whether they should be paying that rent. I don't know what I signed and all that. So these rent guarantee companies, I think, are going to be more prevalent now under the new regulations.
And in terms of if someone's self-managing and they are vetting the potential tenants, what sort of vetting process do you think they should be thinking about in terms of who they are providing accommodation to?
I think, again, this is one of those where you're going to have to throw money at it. It's absolutely imperative to be using a professional referencing company to do that. You can still self-manage, that doesn't stop you. But the amount of checks and balances now that have to be done, especially with the new financial sanction checks that came in on the 14th of May, a lot of landlords don't realise they're supposed to be checking both guarantor and tenant against those sanction lists. So paying a referencing company to do those checks, you want to make sure their employment checks out. Do they earn enough? It's not possible to do a criminal record check, unfortunately, but you certainly can ask for the tenant to do their own DBS check. You want to be checking CCJ registers, all of these things to make sure they are as well-rounded a human being as they possibly can be. But also, on the balance of it, if they do have a CCJ, is that going to be detrimental to them renting? Was it because it was a mobile phone contract 6 years ago that they didn't pay? On balance, that's not really going to impact them paying rent as a good tenant.
Yes. Yeah, you have to make a judgment on that. And I think it's not just simply a computer says no, you need to look at the circumstance and situation, what's led to that. And I guess one of the the things that many people are not very good at doing is managing arrears. So if a tenant's fallen behind, they're a little bit late. So at what point do you do what? What's your thoughts and advice on how to manage arrears and prevent them happening in the first place?
Preventing them from happening, I think, is easier than actually dealing with them once you've got them. First of all, even as a self-managing landlord, have a rent arrears policy. Now, most people think that these are only for businesses, but they're not. Because as soon as the tenant hasn't paid the rent or they're short, you are emotionally involved. A rent arrears policy will give you clear lines of instruction of what you're going to do, and it removes the emotion a little bit from it. I would always say the second the tenant is a day late or a penny short, that's when you're taking your first step. Pick up the phone, speak to the tenant. None of this text messaging, private message, we're not having any of that, because the problem you've got is people will read a text message or texts in general in the frame of mind they're in, not in the tone that it was sent. So you could spend 2 hours writing the perfect text message. Yeah, I've got that right. Send. The tenant's got the ump. They're going to read that with the ump and think you're an arse.
Yes.
So a tone of voice, you can hear if someone's scared, if they're genuine. That tone of voice is really important. And the opening conversation is important as well, because you don't want to be picking up the phone and going, "Where's my money?" That's not going to end well.
Yes.
"I see you haven't paid your rent. Is everything okay? Is there anything I can do to help?" Completely changes where that conversation is going to go.
And often you'll agree something with a tenant when they're going to pay and how they're going to pay. And if those promises are not met, at what stage do you start then becoming more firm in terms of approach and pursuing potentially legal routes? How much space do you think is practical?
I think after having that initial conversation, you're going to know in your gut whether this is a tenant that can't pay or won't pay, and whether their excuses are genuine. I mean, we've all had the tenant who's been the most unfortunate human being. Their mum's died, the dog's died, grand's died, next door neighbour's died. We've all had them. We know that that's just story after story. So I think...
Especially when the nan dies twice.
Yes, absolutely, because they've forgotten.
Yeah.
But I think, again, it's going to be about managing that situation, but then you've got your rent arrears policy to refer back to. So have that conversation, give them, 5-6 days to sort themselves out. Can you pay? No. Then just send them a letter that explains formally what's going to happen next, so they understand the process.
Yeah.
And then ultimately, once they are exactly 2 clear months in arrears, you need to be issuing that Section 8.
Yeah.
Doesn't necessarily mean you're going to move forward to court, but they then certainly understand that you mean business.
Yes. And you start the process.
Yeah.
So you can always retract it later.
Absolutely. Yeah, you don't have to go to court with it.
Yes. So when a tenant is in arrears, we have to try and understand what's caused it, what's going on, but there can be some other support available for them as well.
Yeah, absolutely. I mean, if you think of most businesses, they will have a specific debt collection department that deals with their customers that are struggling to pay. So as landlords, we need to be doing that and having that mindset as well.
Yeah.
We've got a customer that's struggling to pay. What can we do? Now, I'm not saying that landlords should suddenly become, debt specialists and social workers and housing advisors. It's important to know where you can signpost a tenant to. So did you know there is at least £107 billion available for tenants to tap into when they're in rent arrears that they can access to pay that money off? So landlord's got the money in the back pocket where it should be, and tenant doesn't have the debt and threat of eviction.
Yeah.
It's important for landlords to know they can signpost tenants to that support. And that support is both from the local council and individual charities, legacies and grants.
That's amazing. I didn't know there was that much available. So if a landlord is in that situation, what would be their starting point? Where should they start exploring some of this information?
So absolutely. And it depends how engaging the tenant is as well, because sometimes when we're in debt, we bury our heads and we don't want to talk to anybody. So the first thing that I would suggest that a landlord does is try and get the tenant to engage with local debt support, so citizens advice or step change or something like that. Once they've got them engaged, then really they're a bit of a hand-holding service for the tenant and they will help them explore. If the tenant doesn't want to engage with them, then it would be speaking to the local council to see what funding they have available from the Homeless Prevention Fund or the Financial Inclusion Funds.
And it's interesting, I never really thought about it in this way as you were just speaking about it now. It just got me thinking. It's really in the council's interest to try and help, because ultimately they're going to become their problem then otherwise once they've been evicted.
Absolutely. And on average, it costs the council around £32,000 per applicant to house them through the homelessness system.
Wow.
So if a tenant's got £3,000 or £6,000 of rent arrears, it makes much more sense to pay it out of the homeless reduction fund than it does to have to go through the process of housing that person.
Yes. And something else you just touched on there is the maybe the burying your head in the sand. That could be the tenant or could be the landlord as well.
Yeah.
Some cases. What's the appropriate way to communicate these conversations? And for example, you get the younger generation that will be sitting next to you but texting you rather than having a conversation with you. I'm exaggerating a little bit, but you get my point.
Yeah, absolutely. And like I say, speaking to someone is always really important because you get the tone of voice. You can hear whether someone's being genuine. And body language is always a big thing that we pick up on more than we actually do anything else. But if they're only going to communicate by email or text, then you need to make those texts and emails as clear as possible. So no hidden threats or underlying agendas. It's just really clear, concise information. If you found links to local citizens advice or something like that, embed those in so they can just click.
Right.
We're in a very much a society where it's instant. Everybody wants everything now.
Yes.
So if you can already do a bit of research for them and give them the links for them to click through, that's usually much more productive than then having to search for themselves.
Okay. And this is a topic we've spent hours and hours talking about, and I'm sure as it will evolve and probably a part 2 for us to pick up and do again. And you spend a lot of time helping landlords, helping letting agents as well, whether it's non-registration deposit or whether it's just learning and understanding the current changes that we're going through. So if somebody wants to reach out and connect with you, what's the best way for them to do that?
Really and truthfully, either find me on social media or come direct to my website, which is gothardrow.com.
Excellent. And we'll put that on the screen and also link in the description as well.
Perfect.
So Julie, thank you so much for your time today. I really appreciate it. Some good learnings in there for me as well today.
Great. Thank you for having me.
Thank you.